How to leave rental real estate to multiple children without causing a family fight. It's a simple fact of life. We all live and we all pass on. If you own a California home, a rental, or investment property, you're probably wanting to leave it equally to your kids. That sounds fair, but here's the hidden problem. Equal ownership means every single decision from fixing a roof, leak, raising rent, to picking a realtor becomes a group vote.
I want to sell it, but I want to keep it.
And that is exactly how family feud starts. One sibling can file partition, probate can stall decisions for months, Proposition 19 can turn a long-term rental into a money loser. I have seen this happen too many times, and I have even watched it tear families apart. That is why I'm making this video with the help of my kids to show you how to stop that conflict before it starts. I'm Talai, trust and asset protection attorney and founder of Talai Law Offices. Let's begin with the number one problem. One house and too many children problem. Let's say you own a California rental or two, maybe a family home as well, and you want your children to benefit from what you have built. Most parents assume that the fairest approach is to leave the property to all the children equally. On paper, that feels right. In real life, equal shares without a clear structure can light the fuse on years of conflict. Once siblings inherit as co-owners, every decision requires alignment. Should they sell or hold, rent or renovate? Which realtor to hire? What rent to charge? Who fronts cash for a new roof when there's a leak? Even routine maintenance turns into a debate when everyone has vote and power and no one is clearly in charge.
That sounds like a headache.
Exactly, and here's where law and family dynamic collide. When a house or a rental passes by a will or under intestacy law, children usually take title as tenants in common. That form of ownership gives each co-owner the same undivided right to the whole property. It also gives any co-owner the power to ask the court for a partition order. Under California Code Civil Procedure partition statutes, the right to partition is close to absolute unless there's a valid writing waiver. Judges generally will not force unwilling co-owners to remain tied together. If the owners cannot agree, the court can order a sale and divide the proceeds. And now you layer probate on top of that and stress multiplies. Real property that is not held in a trust or by survivorship typically goes through probate. Probate is a public process, slow, very slow, and expensive. It invites formal objections when emotions are raw. Months can pass while the state awaits on hearings. During that time, taxes and insurance obviously will become due. Tenants will probably have some sort of repair that someone has to fix. And unfortunately, patience of otherwise reasonable people, beneficiaries, starts to fray. By the time that the court finally transfers title, the sibling may already be dug in about what should happen next, and cooperation is harder than it needs to be. This is why an estate plan is not a luxury. It is a productive device for both assets and relationships. With the right structure, you can keep your children out of the probate court, avoid the forced sale risk that comes with co-ownership, and set rules that turns property from a flagship point into a durable gift. The goal is not simply to be equal. The goal is to be clear, fair, and practical so your children preserve the value of real estate and their relationship with each other. All right, so let's talk about the core solution that could prevent fights. The single most effective tool in California is a revocable living trust. A trust avoids probate and lets you hand your successor trustee a rule book that reflects your values and your numbers. Instead of dumping an undivided interest in a duplex or a fourplex into the laps of your three children and telling them to figure it out, you direct a trustee to manage or dispose dispose of that asset according to a written instructions that you put together and you control. You can tell the trustee to sell the property and divide the cash equally. That simple step eliminates the classic clash between the child who wants to keep his sentimental home and the child who would prefer cash for a down payment or retirement. If you want the asset kept as a rental, your trust can require the trustee to continue to operating it that exact way, reserve funds for taxes and insurance and capital improvements, and distribute whatever it's left, the net income, on some sort of a schedule, bi-monthly, every quarter. If one child wants to keep the property, the trust can give that child the first right to buy at an appraised value, funded by insurance or structured note. You can also empower the trustee to accept partial buyout and equalize the others with cash or other assets.
So everyone knows the rules.
Exactly. The trust is the rule book. This is a long video? She thinks this video is too long, so I'm going to continue telling you about California law. And California law gives you tools to fix common mistakes. If you sign a trust, but you forget to retitle a property into it, the state of Hexstad decision allows a court to confirm the assets as the trust property through a petition under Probate Code Section 850. A Hexstad petition is a safety net, not a plan, but it can save a family from full probate when the intent to hold the property in trust is properly documented. A trust also helps with control. You choose the referee. I often recommend a neutral fiduciary when the stakes or emotions are high. That person follows the script you wrote in the trust. If a decision requires judgment, it comes from one responsible authority rather than three siblings negotiating every roof leak and rent increase. You can also build in mediation or short cooling off period before any distribution decision or buyout is final. In short, a revocable living trust keeps decisions in one lane, replaces conflict with process, and puts your wishes ahead of the loudest voice in the room. All right, let's talk about taxes that can make or break the plan. In California, property tax and capital gains tax rules can decide whether your children can afford to keep a rental property. Proposition 19 reshaped parent-to-child transfers with limited exceptions for a primary residence that a child promptly makes into a primary residence. The transfer of a rental property to children triggers reassessment at the current market value. That can raise the yearly tax bill dramatically. If a duplex has been under Proposition 13 for decades, a reassessment can produce a tax bill that is several times higher than what you paid. Some families unfortunately discover this too late, that this new reassessment will take a rental property that used to have some sort of cash flow and now it's got negative cash flow, and unfortunately it forces the family to sell the property under pressure.
Wait, so they lose money?
That is right, and the right plan can prevent that. First, decide the goal. If no child intends to live in the property and taxes will jump, the cleanest outcome usually is a planned sale by a trustee with a fair division of proceeds. Second, if a child wants to live in the former primary residence and can qualify for the limited exclusion, shape the plan, the estate plan, around that outcome and equalize the other children with different assets or a promissory note, or maybe you purchase a life insurance and you allocate the proceeds from the insurance to them. Also, do not undermine your children's future tax position by transferring highly appreciated property during your lifetime without legal advice and tax advice. A lifetime gift carries your tax basis, which can saddle the next generation with a large capital gains tax when they sell. By contrast, an inheritance at death usually gets a step up in basis to fair market value under current federal laws, and that step can wipe out decades of appreciation for capital gains purposes if the property is sold after parents have passed away. Trusts solve probate and control, but rules on the ground keep siblings out of court. Think of the trust as a family operating agreement. If property will be shared, spell it out. How is it supposed to be managed? Who is supposed to approve the budget that is needed to, operate the property? How many contractor bids are required if there needs to be a new roof placed on the property? Require reserves for taxes within the trust, insurance, and big repairs so no one feels unfairly burdened that they have to come up with the funds to fix the vacation home. Set a predictable distribution schedule for income. Define whether any child can use the home and when they can use it, or how they're supposed to come up with the schedule that, which child can use the property. And include a buy-sell agreement. So if one wants to get out, they can be bought at appraised value. And if no one buys, the trustee can sell the property.
So no fighting.
That is the goal. Protect the property and the family. If you also own property outside of California, there's one more trap that can undo even the best plan. My next video is called, Is Your Out-of-State Property Going to Drag Your Heirs into Multiple Probate Courts? It shows you exactly how to avoid duplicate cases and keep your family on one efficient track. Don't miss it. It's essential for protecting your legacy.
Don't fight about houses!
Well said. I will see you in the next video.